Court does call the case. People versus Rebecca Valentine.
Epsilon for the people. Assistant Public Defender Chinaze Carey on behalf of Rebecca Valentine, Your Honor.
Valentine, can you state your name, please?
Yes, and I did say
Rebecca Valentine's case opens the session with instant tension. A defendant challenging courtroom norms by rejecting counsel always grabs attention. This is where legal autonomy meets practical risk. Under U.S. law, a defendant has the constitutional right to represent themselves, but judges must confirm that choice is made knowingly and intelligently. Here, Rebecca's tone shows defiance more than confidence. She interrupts, asserts control, and tries to redefine the judge's role. It's not confidence, it's friction. This opening is packed with power dynamics, a citizen testing the limits of legal procedure. You can almost sense Judge Simpson's restraint as he balances patience with authority. When she says, "I don't wish to have an attorney represent me," the courtroom freezes. Viewers, what do you think? Is Rebecca brave for standing alone or reckless for rejecting legal help in a system built on complexity? Either way, this opening sets the tone for confrontation cloaked in legal formality.
I want to represent myself, so I don't know where that communication was spilled. Rebecca Valentine, I don't wish to have an attorney represent me.
Okay, you want to represent yourself in this matter?
Yes.
Okay, so what do you want to do today if that were the case?
What are my options?
Pardon?
What are my options?
I can't apprise you of that, ma'am. I can't give you legal advice.
Probably just adjourn it for 2 weeks and they could let me know what they want to do next.
Have you spoken to the public defender or an attorney at all, ma'am?
Yes, she was very inconvenient and non-communicative with me, and I let her know I would like to represent myself. I think that you're allowed to tell me like reasonable information, and then I can make a reasonable choice about my own representation. Is that not my right?
Well, thank you for letting me know what my job is, but that's not how it works.
Rebecca's frustration spills out here, and it's more emotional than legal. Her claim that the public defender was inconvenient reflects a common tension. Defendants often confuse poor communication with incompetence. But her insistence on self-representation comes with weight. Once she waives counsel, she loses a safety net. Judge Simpson's response, "Thank you for letting me know what my job is," delivers quiet sarcasm, a subtle rebuke wrapped in professionalism. It's a reminder that courtroom decorum isn't a debate club. Rebecca may think she's asserting her rights, but she's actually cornering herself into a high-stakes solo act. The judge's decision to adjourn shows procedural fairness. He's giving her time to rethink. This moment teaches a key lesson. In court, asserting control without understanding the system can make you appear bold, but legally, it's a self-made trap. Would you represent yourself in a criminal case?
You're welcome, but I would think you should know this already.
October 24th, 2024, 9 a.m.
Sounds
I will
good.
consider that a waiver of her time requirements. Bond continued. Thank you.
You're welcome.
Should I put anything on the record?
What'd you say?
I guess it would be fair. For the record, Your Honor, I did try and reach out to Ms. Valentine.
How'd that go?
It didn't go very well, Your Honor.
Oh, I'm just asking. I don't know. You don't have to answer me. That would be privileged. Did it go as well as my conversation just now?
You actually heard her voice. So
Oh, okay. That must be part of my charm. Court calls case People versus Wayne Eggleston or Eggleston.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Eggleston. That's just me. You're going to get sentenced by Judge Brusher and not Simpson. I'll draw rights that we talk about. Thank you, Mr. Allen.
Your name, sir?
Wayne Eggleston.
All right, I have before me a plea form that indicates defendant is going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle, 1 year offense. Upon his successful plea to that charge, count one would be dismissed. I guess that's SA is sentence agreement.
That's correct, Your Honor.
Sentence agreement to 1 year in jail, which this court cannot bind the sentencing judge to, although I understand it's your agreement. And no delayed or deferred. Again, this court is not binding the sentencing judge to that.
Thank you.
That's correct, Your Honor.
Seven sworn.
Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Wayne Eggleston.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle.
Correct.
All right, that's a misdemeanor punishable by up to 1 year incarceration and a $750 fine plus court costs, as well as license suspensions by the Secretary of State. You understand that?
Yes.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Correct.
All right. Still wish to plead guilty?
Yes, I do.
Switching to Wayne Eglon's plea, the courtroom mood shifts. Unlike Rebecca's defiance, Wayne's demeanor is compliant. He's cooperative, even submissive. This shows the two extremes of courtroom behavior, self-representation chaos versus plea conformity. The judge's tone here is procedural precision. He's ensuring Wayne's guilty plea is voluntary, factual, and legally valid. When Wayne confirms he's not being threatened, that he's pleading freely, this is all about safeguarding due process. But the deeper layer? This is the legal system's efficiency mode, mass plea bargaining to clear dockets. The judge ensures the record is airtight, but the humanity gets stripped away. The defendant becomes data, a name, a charge, a plea. Still, notice Wayne's hesitation. His responses are short, mechanical. He's saying yes to everything, maybe without full comprehension. The tragedy of many misdemeanor courts lies right here, in quiet compliance disguised as consent.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct, sir?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
All right. Which one?
Probation.
All right. Were you on probation at the time of this offense?
No.
You sure? You don't know.
It's the same offense in a different county. Same day, same offense. Different charge.
All right. So you're on probation in another county
For this.
that happened after or for this, but the events occurred in a different county.
Yep.
Okay. Then I don't think you did.
Another different charge, different county, same case.
Same possession of the same vehicle in a different county.
Yep. Same vehicle, same accident. Yep. Different county.
All right.
Add another charge to it. Yep.
All right.
Now the absurdity peaks. Wayne admits to the same incident being prosecuted in 2 counties. Same car, same act, double the legal trouble. It's a glimpse into jurisdictional overlap, where one mistake multiplies into multiple charges. The judge's calm reaction shows years of experience. He's seen this kind of bureaucratic mess before. For the viewer, this is a legal headache disguised as comedy. Imagine crashing one truck and facing 2 courts. The judge methodically untangles the confusion, but the bigger picture stands out. Fragmented justice. Every county acts like its own small world, each enforcing the same law differently. For content creators covering courtroom clips, this scene is gold. It captures the legal absurdity and human fatigue that fuel viral moments. What's your take? Should overlapping counties be allowed to charge separately for the same act?
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced?
No.
You're doing this voluntarily
Correct.
of your own free will
Yes.
because you believe that you are indeed guilty?
Yes.
July 23rd, 2023, at the location of 9575 Austin Road, Bridgewater Township, Washington County, State of Michigan. What'd you do that makes you think that you're guilty?
I used one of the work trucks and got in an accident.
Did you have permission to take that truck? For that purpose?
Not to get in an accident, no.
Well, did you have permission to take the truck at all?
Depending on the circumstance, but no, let's say no. Let's go with no.
You had permission to take the truck for work purposes, correct?
Yes,
And you took the truck for non-work purposes?
correct. There
And
you
you
go.
didn't have permission, is that correct?
Correct.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, John.
Whoa, not the.
Oh, he thinks it's funny that it's,
I don't think anything's funny about it, sir. I'm just telling you, you weren't answering my question.
I used the truck for non-work purposes, so I didn't have permission at the time that I took it. Correct.
I'm sad. Defense is satisfied. Thank you, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
This moment is textbook sentencing prep, but the subtle drama is in Wayne's tone. When he laughs and says the judge thinks it's funny, it exposes tension bubbling beneath polite procedure. Courtrooms thrive on controlled seriousness, so humor can be misread as mockery. Judge Simpson diffuses it fast. He keeps professional distance, reinforcing authority without escalating emotion. This is where courtroom psychology plays out silently. Defendants often use humor to mask fear, but judges interpret tone as respect or disruption. Here, the judge's quick pivot back to order reclaims the room. The legal takeaway: once a plea is accepted, the defendant's fate is sealed for that count. No redo. The emotional takeaway: justice is mechanical, but reactions remain deeply human. Watching Wayne's uneasy smirk fade under the gavel's rhythm captures the uneasy mix of guilt, relief, and resignation.
Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
October 29th at 9 a.m. before Judge Fresh Hour.
October 29, 2024, 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus James Johnson.
People.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Johnson, Your Honor. Mr. Johnson is approaching the podium.
State your name.
James Johnson.
Good morning, sir.
Your Honor, this is the time for a probable cause conference. We have reached out to the people in regards some video. And I've communicated with Ms. Lundy, and she says she's informed me that it is in the process. We'd ask the court to adjourn this briefly so that I can obtain that video.
How much time will it take the people to get that to them?
We could do 2 weeks, I think, would be.
Okay.
I know we want to get that done.
Probable cause conference will be adjourned until October 24th, 2024.
Thank you, Your Honor.
Bond will continue. Thank you.
Actually, Your Honor, could I ask the court to set a nominal bond in this matter? Right now, his bond is personal recognizance.
Okay.
We live in
Except
markedly
I tried
different.
to, hold on. I tried to do that the last time. Mr. Johnson told me he didn't want me to do that and that it wasn't his first rodeo.
Yes, Your
I remember it real clear. So now you want me to set a bond?
Yes, Your Honor, please.
You want me to do that, Mr.?
Yeah, something low.
Huh?
Yeah, send me something low. What's up, Alan?
Set bond in this case is 1,000. I'll give it 10% privilege.
The James Johnson segment delivers a classic courtroom laugh-out-loud exchange. Judge Simpson reminds everyone who holds the power, "You told me last time you didn't want me to do that, and it wasn't your first rodeo." That line hits like stand-up comedy with legal teeth. Beneath the humor lies a psychological duel. A defendant testing control, a judge subtly reminding him who sets the rules. Bonds are not favors, they're calibrated risk assessments. Setting it at $1,000 with 10% is leniency mixed with discipline. Simpson's ability to joke while staying authoritative is rare judicial charisma. This kind of exchange keeps courtroom watchers glued, sharp wit wrapped around hard consequences. The lesson? In court, familiarity with the system can make you bold, but boldness doesn't equal leverage. What's your verdict? Was the judge's humor fair or slightly petty?
And that day was October 25th, correct, Your Honor?
Sure.
Thank you, Your Honor.
He just wanted to tell me no. That's why he said it the last time. Yeah, I know. Court calls case people versus Dondre Roberts.
Epsilon people.
Assistant Public Defender in the Apple appearing on behalf of Simpson, who's approaching now. You state your name for the record. Hold up right here.
DeAndre Robinson.
Thank you. Your Honor, the court should see the receipt of a plea form in this matter.
Yes, I have a plea form that indicates that he's going to plead guilty to attempted resisting and obstructing the 1-year offense. Upon the successful plea to that charge, count 1 would be dismissed. And the people agree to immediate sentencing, but I don't know that I do. Why is that?
I've been in communication with the police officers who were involved in this. They're approving of immediate sentencing. The defendant has a hold out of the city of Texas. And I believe wishes to go and address that as soon as possible. The deputies were understanding of that.
And that's correct, Your Honor. That's our basis for requesting the time served immediate sentence. He has waived extradition, so as soon as this case is resolved, he will proceed to Texas.
Have him sworn.
Raise your right hand.
DeAndre Robinson's case begins with rare clarity. No arguments, no confusion. Yet beneath that calm, there's tension. He's pleading guilty to attempted resisting and obstructing, a charge that sounds small but carries weight. It's a year in jail and a $1,000 fine max, meaning this plea is strategic. The defense and prosecution both want quick resolution, partly because DeAndre has a Texas hold waiting. This moment shows how state and interstate systems overlap. Judge Simpson ensures every word is by the book. He's protecting the record while managing a man already entangled in another state's probation. For viewers, this is courtroom chess disguised as routine paperwork. The real story? Efficiency meets empathy. A man just wants to clear one case to face another. The judge's patience reflects institutional compassion, even under procedural monotony. Would you call this fairness or just bureaucracy in motion?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
DeAndre Robertson. All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted resisting and obstructing. That's a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand that? Well, I will be your sentencing judge. So understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
I plead guilty, sir.
Okay, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. There's a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Oh, man.
Let the judge know.
No, sir.
He has no further questions.
Okay. You understand you're giving up those rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Out in Texas, yes.
Pardon?
Out in Texas,
Which one?
that's probation.
Probation? Were you on probation in Texas at the time of this offense?
Yes.
Okay. I do have to advise you that this plea in this case could be a violation of that probation that you have.
Yes, sir.
This is where the courtroom turns ethical. Judge Simpson carefully warns DeAndre that pleading guilty here might violate his probation in Texas. It's a moment of moral clarity. The judge doesn't just process him, he ensures DeAndre comprehends the consequences. When DeAndre responds, "No, sir," it's revealing. He's not being difficult, he's overwhelmed. Courts assume legal literacy that many defendants lack. Simpson's repetition shows judicial patience, a teacher's tone in a system built for efficiency. This exchange highlights one of the biggest problems in American justice. Informed consent isn't always truly informed. A defendant can agree without understanding. For creators analyzing this clip, this scene delivers depth. Law meets empathy. Procedure meets human confusion. The judge's tone remains steady, his duty clear. Protect due process even when comprehension lags behind.
And that court, if it does consider it a violation, could sentence you to the maximum allowable under that other charge. You understand that?
No, sir.
You don't understand that?
You said it's a violation.
If it's considered a violation, that court could sentence you to the maximum allowable under that other charge that you're on probation for. You understand that?
Yes.
Understanding that you still wish to plead to this charge.
Yes, sir.
I'm sorry, I didn't hear you.
Yes, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
They promised me that the deal with this case, it'll be dropped to a misdemeanor. And then I'll be sent back to Texas.
Okay. Don't know about the sent back to Texas part, but it has been reduced to a misdemeanor. That's what you're pleading to. All right. Anything else anybody promised you? No?
Basically, all I heard was being transferred once I signed for a misdemeanor.
In the only promise that was made is that the felony would be reduced to a misdemeanor, correct? Which was stated on the record. Yes. No other promises have been made to you to get you to plead guilty
No, ma'am.
today. Thank you.
Has anybody threatened you or coerced you in any way to get you to plead?
No, ma'am. No, sir.
You're doing this voluntarily,
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty?
Yes, sir.
September 29, 2024. Location of Sweet Road and Holmes Road, Ypsilanti Township, Washtenaw County, State of Michigan. Did you come into contact with deputies from the Washtenaw County Sheriff's Office?
Yeah.
What happened?
Your Honor, may I have one here?
Yes, please.
Thank you. On that date and time, Mr. Roberson, did the officers attempt to pull you over? Did they conduct a traffic stop and you saw their lights behind you?
Yeah, there was it was white at first. You know, they put white on the license plate so they can read it and get the information off the license plate. And then
And Mr. Roberson, based on the information from the plates, they conducted a traffic stop.
yes, sir.
Okay. And you knew that they were officers conducting a traffic stop?
No, all I thought was they was just reading the license plate.
Okay. But at some point they activated their overhead lights and in their lawful duty were attempting to stop you in your vehicle, correct?
Yes, sir.
Okay. And you ultimately did stop your vehicle, correct?
Yes, sir.
Okay. And then you proceeded to get out of the vehicle and run,
Yes, sir.
correct? And you did not comply with their commands?
Yes, ma'am.
Defense is satisfied.
Counsel. Madam Prosecutor.
People are satisfied, thank you.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Your Honor, I would ask the court to impose minimum fines and costs. As the court is aware, Mr. Roberson is going to proceed to Texas to handle his matter there. So I'd ask the court to take that.
How long has he been locked up here?
He has been in for 12 days, Your Honor.
Is there anything you want to say before I impose sentence?
I just want to apologize for my actions.
This is one of the most human moments in the entire session. DeAndre, standing humble and regretful, delivers a rare, full apology. No excuses, no deflection, just ownership. Judge Simpson's minimal response shows quiet respect. Courts rarely reward emotion, but judges recognize sincerity. The sentence, 365 days with 12 credited and the rest suspended, reflects compassion balanced with accountability. What's fascinating here is the psychology. DeAndre's emotional tone shifted the energy of the courtroom. Even the judge's voice softened. It's proof that remorse, when genuine, carries power. This is redemption in procedural form. Viewers watching might ask, does the system forgive easily, or is this mercy tied to efficiency? Either way, this clip captures rare dignity in defeat, a reminder that humanity sometimes survives even in bureaucratic justice.
And that I should have complied with lawful, and I should have stopped. And I want to apologize, Your Honor.
All right.
And that's it.
Fines and costs of state minimums of $125. All order 365 days in jail. Credit 12 days. The balance is suspended. All right.
Thank you, Your Honor.
Thank you. Good luck to you, sir.
Thank you, sir.
Court calls the case of the people. Court calls the case people versus Brian Haggard.
Mike Jennings, public defender on behalf of Mr. Haggard, who's approaching as well, Judge.
Your name, sir?
Brian Haggard, Your Honor.
Thank you. Nope.
Maybe I could give that, we could exchange.
Change the two things.
Your office right now. It
All
does include positive tests for cocaine. And it is a case that I am requesting an adjournment. It came in as an OWI investigation. I wanted to charge it immediately, given this person's substantial substance abuse and the violence given to the police officer, given that it's an RNO case. Since then, his blood has come back, and I am ready to move forward with an OWI third charge against him, that I'll need to authorize that and then have it resworn to, and then if we could.
The Brian Haggard case begins like a procedural routine, but quickly unravels into addiction and contradiction. His record reveals repeated drug positives, and the courtroom's patience thins. The prosecutor's tone is assertive, detailing benzodiazepine, buprenorphine, and cocaine findings. But here's where viewers should pause. Addiction and crime blur dangerously. The prosecutor wants accountability. The defense wants understanding. Judge Simpson's calm tone again anchors the storm. He listens, dissects facts, and ensures nothing emotional contaminates the record. This is where law meets biology. Addiction isn't a defense, it's context. Still, the data doesn't lie. Repeated positives, consistent violations. For a viewer, this is frustrating yet revealing. How does the court balance rehabilitation and punishment? That's the silent debate under every bond violation. Should repeated relapse mean jail or treatment?
Just the bond violation as well. I'm sending this in, but summarize September 5th, benzodiazepine and buprenorphine positive, November 11th missed, November 12th, those same three substances, as well as cocaine, despite not earlier. November 20th, positive for those two substances as well as cocaine.
November.
Yeah, I'm not reckoning we got there yet.
I'm sorry, I'm meaning to say September. I'm so sorry.
Thank you.
September 5th, September 11th, September 12th. I apologize.
Got it. It's okay.
September 20th, buprenorphine, cocaine, THC. September 24th, missed. September 28th, buprenorphine, THC. October 3rd, buprenorphine, THC. Sorry for that.
All right.
It's in my car.
12,
I
cocaine
haven't
positive
sure.
is confirmed by Redwood Toxicology. And that is.
Okay. You said cocaine was confirmed?
Yes.
Your Honor, while we don't have, since there's another case coming, we don't, it doesn't make sense to hold the exam on the RNO, than to set the other one. So I wouldn't object to the adjournment. Actually, I filled out the green form, so I guess I don't. In terms of the bond violation, Your Honor, I believe there's been some tests as of late. He does, Mr. Haggard does have a prescription for the buprenorphine, the Suboxone that we can provide to. They should have.
Okay, so what about the cocaine?
Your Honor, he denies that. We've certainly he sent that out to the Redwood had community corrections send it out to the Redwood lab for verification. I believe it did come back. I believe there has been tests since then. These tests were in September. We're now almost in double digits in October. I'd ask the court to adjourn this matter and keep the bond violation pending to allow him to demonstrate to the court that he can comply with the court's testing, not just its directives, but its mandates that he not test positive for these substances.
This time, I'm going to adjourn this out. I'm only going to adjourn it out 2 weeks. He's going to have some other type of plan in effect or some other type of thing. But at this time, I'm going to revoke the defendant's bond. Defendant's remanded to the Washtenaw County District.
This decision lands hard. Judge Simpson's patience has limits. After hearing the defense argue for leniency, he draws the line: bond revoked. In legal terms, that means Haggard's trust with the court just expired. In emotional terms, it's a controlled disappointment. The judge's tone is surgical, measured but final. No anger, no insult. This kind of firmness is essential to authority. Justice isn't persuasion, it's consistency. The takeaway here is about accountability. When a defendant repeatedly fails drug tests, the court's compassion becomes conditional. To viewers, this ruling feels both fair and harsh. It's that tension that makes courtroom footage addictive. It shows how justice balances empathy with order. Every viewer watching this has a personal verdict. Is Simpson too strict or perfectly fair?
It's just so awesome. Court calls the case. Oh, yes. Good, thank you. Court calls the case, People versus Joseph DeLiz.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. DeLiz, who is present via Zoom, Judge.
Sir, can you unmute and state your name? Are you trying?
Are you able to ask someone, sir?
We're trying to force him, but Mr. Hlood, good morning. Now, sometimes while we wait, sometimes you just have family hanging around. And sometimes when you have family hanging around, they're sometimes doing things that they probably shouldn't be doing.
I already know.
Right next to you, but it's okay. She already knows?
Yeah.
Okay.
Great. Picture right here.
Not so much. No. Is he? So we can't force him? It's not. Okay. Let me just pass it briefly and
Thank you, Your Honor.
see. Oh, no. I thought somebody was coming in there now. Okay. We'll call you back up in a moment as soon as we can get you unmuted, Mr. DeLeese. So
Can we approach on DeLeese?
no.
I think they brought the wrong guy. Our guy is 34 years old. And I just looked at
Might be a rough life. Maybe. I don't know. Your guy is what?
Joseph Chad DeLeese, born in 1990.
Wow.
I just looked at his Otis photo.
Is this Mr. DeLeese? And they said yes. It's just bad language. That's all I got.
What year was he born?
1990.
So he should look like him. Yeah.
Said he looks like him. Said he looks like him.
It looks like Mike. So that's probably the wrong guy. Are you sure that date of birth is?
Joseph Chad DeLise is who we're looking for.
Are we gonna be able to check? Are you?
Check what GIS says.
Well, that's what Mike did. March 27th, 1990? Okay, well, it might be him. Why don't we ask Wayne County what this guy's date of birth is? Mr. DeLise, can you hear me? Shake your head if you can hear me. Okay, were you born in 1990? Shake your head if it's a no. Yeah, I didn't think so. All right, so that's probably the wrong guy. Huh? Officer, thank you. We're looking for a Mr. DeLise that was born in 1990. I don't think this is him.
Okay.
Okay.
And it's John DeLise, is that?
Pardon?
And is John DeLise the name?
Well, it's Joseph, I think.
Joseph?
Is that who we're looking for?
So yeah, this
We're
is
looking
John.
for a Joseph Chad DeLise.
32790.
32790.
Okay, yes, you are right. It does say Joseph. So we don't have a Joseph in custody. So
You don't have him?
no.
Alrighty. Thank you. And
My
Mr.
apologies.
DeLise, thank you. Not a problem. So
The final case, Joseph DeLise, turns into pure courtroom theater. A mistaken identity scene unfolds like a dark comedy. Wrong man, wrong birth year, total confusion, judicial chaos in real time. Judge Simpson handles it like a veteran, switching between humor and control. Might be a rough life. The courtroom laughs, but the undertone is serious. Errors like this expose systemic cracks. The legal process depends on accuracy, and one mix-up can derail justice. What makes this clip viral-worthy is its absurd realism. It's bureaucratic comedy inside a solemn ritual. The judge ends professionally, adjourning the matter until the real defendant appears. And that's the perfect close. From defiant defendants to honest apologies, today's docket spanned the spectrum of human behavior under law. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.